In October of 1837, a man named Nicholas Farwell was doing his job. He was an engineer on the Boston and Worcester Railroad, one of the best paid working men in Massachusetts, earning about $2 a day for running a locomotive through the countryside outside Newton. He was skilled, he was sober, he was careful, and on that particular day, he did absolutely nothing wrong. Somewhere up the line, a switchman named Whitcomb left a switch in the wrong position. The train went off the rails. Farwell was thrown from the engine, and the wheels of his own locomotive rolled over his right hand and crushed it. He was a one-handed man now. In 1837, a one-handed engineer was not an engineer. He was finished, so he did the thing that seems obvious. He sued the railroad. The company's employee had made the mistake. The company had put that employee there. The company should pay. And the highest court in Massachusetts told him no. Not because he'd been careless. Everyone agreed he hadn't been. Not because the accident was unavoidable. Everyone agreed it was entirely avoidable. The court told him no because of something Chief Justice Lemuel Shaw was about to invent, on the spot, in that very ruling. Shaw decided that when Nicholas Farwell accepted his wage, he had also accepted the risk that a co-worker might one day kill or maim him. That risk, the court said, was already built into his $2 a day. He'd been paid for his hand, he just hadn't noticed. Here's the part I want you to sit with. Farwell didn't lose because the law was silent on workplace injury. He lost because the law had spoken clearly, deliberately, and against him. And that ruling didn't stay in Massachusetts. Courts across the United States adopted it. For the next 70 years, it was one of 3 legal doctrines that, working together, made it nearly impossible for an injured American worker to collect a single dollar from the company that broke him. 3 doors, all locked, and behind them, an entire century of crushed, burned, poisoned, and buried human beings. This is the story of what happened to Americans who got hurt at work before there was any such thing as workers' compensation. It's the story of a legal trap so perfectly built that most injured workers never even made it to court. It's the story of the deadliest years in American industrial history, when the annual death toll in the nation's workplaces ran into the tens of thousands, and of the claim agents who showed up at hospital bedsides with cash in one hand and a release form in the other. And it's the story of a 26-year-old woman with a law degree who spent an entire year in Pittsburgh doing something nobody had ever done, counting every single person killed on the job in one American county, and used those numbers to break the system open. It's also the story of a bargain, because when America finally built a compensation system in 1911, workers had to give something up to get it, something they have never gotten back. We'll get to that, and we'll get to the price list, the actual schedule, written into law, that assigned a dollar value to a thumb, a finger, an eye, an arm. That price list was the reform. But to understand why this took so long, you have to start with what work looked like before the machines. For most of American history, injury at work was a household matter. In the agricultural economy of the early republic, the overwhelming majority of Americans worked on their own land or in small workshops. If a farmer broke his leg, his family absorbed it. His brothers brought in the harvest. The church took up a collection. His wife and children worked harder. It was brutal and it was precarious, but it was personal. There was no institution to appeal to because there was no institution involved. The apprentice who cut himself in a blacksmith shop lived in that blacksmith's house. He ate at his table. The relationship between the person who got hurt and the person who owned the tools was a relationship between 2 people who knew each other's names. Then came steam. Starting in the 1830s and accelerating violently after the Civil War, the American economy filled up with machinery that could kill you faster than you could react. Textile mills with exposed belts and open gearing. Steel mills pouring molten metal in buildings with no guardrails. Coal mines with primitive ventilation and open flame lamps. And the railroads, above all the railroads, where brakemen coupled cars by standing between 2 moving pieces of rolling stock and dropping an iron pin into a link by hand. You could always tell a veteran brakeman, count his fingers. The scale changed everything. When 1 man in a workshop of 4 gets hurt, that's a tragedy. When 200 men in a plant of 4,000 get hurt every year, forever, that's not a tragedy anymore. That's an output. Injury had become a predictable, calculable, budgetable byproduct of industrial production, exactly like coal dust or slag. And the country had no idea what to do about it because the law it inherited was designed for a world of 2 people who knew each other's names. Now here's the thing that should stop you. Other countries figured this out, and they figured it out first. Germany, 1884. Otto von Bismarck. No one's idea of a radical, established a compulsory national accident insurance system for industrial workers, not out of compassion, out of cold political calculation. He wanted to undercut the socialists by giving workers security from the state. It worked, and more importantly, it functioned. Britain followed with the Workmen's Compensation Act of 1897. Austria, Norway, Finland, Denmark, France, Italy, one after another, the industrialized nations of Europe built systems where an injured worker didn't have to prove anybody was at fault. He just had to prove he was hurt at work. By the time the first surviving American law took effect, the United States, the richest, most industrialized, most productive nation on earth, was roughly a generation behind. So the question isn't why America eventually built a compensation system. Every industrial country did. The question is why America was the last one standing. The answer is those three doors. On paper, an injured American worker did have a remedy. He could sue his employer for negligence. If the company had been careless and that carelessness hurt him, he could recover damages in court. That sounds fair. That sounds like justice being available, if slow. It was not, because American courts over the middle decades of the 19th century constructed three defenses that employers could raise, and any one of them was fatal to a claim. Historians of labor law have a name for them. They call them the unholy trinity. Door number one is the one that ruined Nicholas Farwell, the fellow servant rule. If your injury was caused by a coworker rather than by the employer personally, the employer was not liable. Full stop. The logic, as Chief Justice Shaw laid it out, was that workers were in the best position to watch each other and warn each other, and that the risk of a coworker's mistake was priced into the wage. Now think about what that means in an actual factory. In a plant with 400 employees, who causes accidents? Not the owner. The owner is in an office in another city. Accidents are caused by the man on the next machine, the crane operator, the switchman, the foreman, the kid who was supposed to sweep up the oil. Virtually every industrial accident by its nature involves a fellow servant somewhere in the chain. The fellow servant rule didn't narrow employer liability. It very nearly abolished it. Door number two, contributory negligence. This is the one that people misunderstand today because we live under a different rule. In most American states now, if you're partly at fault, your recovery is reduced by your share of the blame. 70-30, you get 70%. That is not how it worked. Under contributory negligence, if the injured worker was found to be even slightly responsible for his own injury, any amount, any percentage, he recovered nothing, not less, nothing. It was a total bar. Now put that in a real workplace. 12-hour shift, 6 days a week, unguarded machinery running at speed, poor light, deafening noise, no training beyond what the man next to you shouted over the din. Under those conditions, is any human being on earth going to be perfectly careful for 12 straight hours every day for 20 years? Of course not. Everybody reaches across a running belt eventually. Everybody takes the shortcut. And the moment you did, you had handed the company its complete defense. Door number three, and this is the one that gets under my skin, assumption of risk. The doctrine said that a worker who took a dangerous job, knowing it was dangerous, had voluntarily accepted the danger. He'd consented. Nobody made him work in the mine. He could have gone somewhere else. And in a courtroom, spoken in the calm language of contract law, that almost sounds reasonable. It only falls apart when you remember who we're talking about. A man with 5 children and no savings, a recent immigrant with limited English, a resident of a town where the mine is the only employer within 30 miles. The doctrine of assumption of risk treated that man as though he were a gentleman at a desk, weighing options at his leisure, free to walk away. It called desperation a choice, and then held him to it. 3 doors, locked from the other side. And here's what that produced. When researchers finally started measuring outcomes rather than assuming them, they found that the majority of seriously injured American workers recovered nothing at all. No verdict, no settlement, no help. Among families who lost a breadwinner outright, roughly half received nothing whatsoever. And even the ones who did win faced years of litigation, lawyers taking a large share, and companies that could appeal until the widow gave up or died. So that's the legal machinery. Now let's talk about what it was processing. The raw numbers from the early 20th century are difficult to hold in your head. Estimates for annual workplace deaths in the United States in that era run into the tens of thousands, a figure that, spread across a working year, means Americans were dying on the job at a rate of dozens per day, every day, in an economy far smaller than today's. Injuries ran into the hundreds of thousands. In coal mining alone, 1907 was the worst year ever recorded in American history, with more than 3,000 miners killed in 12 months. And 1907 is where the story starts to turn, because of what happened on the 6th of December that year in a town called Monongah, West Virginia. 2 connected mines exploded, most likely from ignited coal dust. The blast was strong enough to shake buildings for miles. The official death toll was 362 men and boys. Almost everyone who has studied it since believes the real number was higher, because miners routinely brought their sons and nephews underground to help. And those boys were never on any payroll. It remains the deadliest mining disaster in American history. And under the law as it stood that morning, the families of those men had no automatic right to anything at all. But raw death tolls, honestly, go numb after a while. What makes this period so much worse than the numbers suggest is the machinery that ran on top of the accidents. Three pieces of it, in particular. The first was the claim agent. Large industrial employers and railroads employed men whose entire job was to arrive at the scene of an accident, or at the hospital, or the family's front door before anyone else did, before a lawyer, often before the family had grasped what had happened. The claim agent came with cash and a document. The offer was designed to be almost irresistible. Here is money, right now, today, in your hand, for your rent and your funeral. Or you can hire a lawyer, wait 3 or 4 years, spend money you don't have, and probably lose because, and the agent would explain this part very clearly, the law is not on your side. He wasn't even lying. That was the diabolical part. The 3 doors made his pitch honest. So the papers got signed. They got signed by men on morphine who could not have told you the day of the week. They got signed by workers who could not read English and were told the paper was a receipt. They got signed by widows in the same week they buried a husband. And a signed release ended the matter permanently, for a fraction of what the loss was worth. The second piece was the company doctor. In company towns and large industrial operations, the physician who treated you was paid by your employer. He set your bones, and he also wrote the report, the document that recorded how the injury happened, whether you'd been careless, how badly you were hurt, and when you were fit to return. That report was evidence, in your own case, against you. Think about the position that puts a man in, lying in a bed, dependent for his life on the medical judgment of someone on the other side's payroll. And the third piece was what happened afterward, which is the part that almost never gets told because it isn't dramatic. It's slow. A man dies in a mine, or comes home without an arm. The income stops that day. There is no unemployment insurance, that doesn't exist yet. No disability insurance, no Social Security, that's decades away. No savings, because there were never any savings. So the household reorganizes. The widow takes in boarders or laundry or piecework she does at night. The oldest boy, who is 11, leaves school and goes into the same mill that killed his father. The younger children follow within a few years. The family that was barely climbing is now permanently below the line, and the children who should have gotten an education have been converted into the next generation of cheap, unskilled labor for the same industry. That's the thing to understand about this system. It didn't merely fail to compensate injured workers. It fed on them. It turned every death into a fresh supply of children who had no choice but to take whatever the mill offered. Which brings us to a Tuesday morning in November of 1909 in the town of Cherry, Illinois. The Cherry Mine was a modern operation, considered one of the better mines in the state. Because the electric lighting system underground had been unreliable, the men were working by open kerosene torches, an ordinary, temporary, entirely routine arrangement. Around lunchtime on the 13th of November, a car of hay, feed for the mules that hauled coal underground, was left sitting near one of those torches. Burning oil dripped into the hay. The men who noticed it weren't especially alarmed at first. Small fires happened. Somebody would deal with it. Then the fire reached the wooden timbers, and the mine's ventilation fan, the system designed to push fresh air down to the men, began driving smoke and superheated gas straight into the working sections where hundreds of miners were digging coal. The hoisting cage went down and came up 6 times, bringing men out. On the 7th trip, the cage came back up on fire, with the rescue party still in it. Every one of those men died. They had gone down knowing exactly what was waiting. Deep in the mine, a group of miners understood that no one was coming for them in time, so they built a wall. They used mud and rock and whatever they could scrape together, and they sealed themselves into a chamber to keep the gas out. They sat in absolute darkness behind that barricade, rationing the air, listening. 8 days later, rescuers reached them. 21 men walked out alive. 259 did not. Many of them were teenagers. And under the law of Illinois, as it stood on the morning of November 13, 1909, not one of those 259 families was automatically entitled to a single dollar. Every one of them would have to prove somebody's negligence and get past the fellow servant rule and contributory negligence and assumption of risk, all 3 of which the company's lawyers would raise before lunch. Cherry broke something loose. It fed directly into a wave of state investigation commissions, and Illinois moved on liability reform within 2 years. 16 months later, in New York, the Triangle Shirtwaist Factory fire killed 146 garment workers, most of them young immigrant women, behind doors that had been locked from the outside. And the argument that America's workplaces were governed by an unacceptable set of rules stopped being a fringe position. But here's where the story gets harder and more interesting than a simple march toward justice. Because reform had already been tried, and the courts had already killed it. Maryland passed an early cooperative accident insurance scheme in 1902, struck down. Montana passed a compensation law for miners in 1909, struck down, and then came the big one. In 1910, New York, the largest industrial state in the country, passed the first compulsory workers' compensation law in the United States, covering a set of especially dangerous trades. It was drafted carefully by serious people after a formal state commission had studied the problem for a year. In March of 1911, the New York Court of Appeals struck it down in a case called Ives versus South Buffalo Railway. The court held that forcing an employer to pay for an injury he had not caused took his property without due process of law. It was, they said, unconstitutional in principle, not fixable at the margins, wrong at the root. That ruling came down weeks before the Triangle Fire. The highest court in the most industrialized state in America had just announced that the entire concept of no-fault compensation was incompatible with the Constitution. And I want to be fair to the other side here, because the opposition wasn't purely cynical, and pretending it was makes the story dumber than it is. Employers raised real objections. A no-fault system meant paying for accidents you hadn't caused and might not have been able to prevent, including accidents caused by a worker's own recklessness. Small manufacturers argued, not unreasonably, that a run of bad luck could bankrupt them where a large corporation would absorb it. Some argued that removing fault entirely would remove the incentive for workers to be careful. And underneath all of it was genuine uncertainty. Nobody in America knew what such a system would cost, because America had never run one. Those are arguments worth taking seriously. Here's why they lost. Germany, 1884. Britain, 1897. By the time Ives was decided, Europe had been operating no-fault compensation systems for a quarter of a century. The data existed. The costs were known. Industry in those countries had not collapsed. In several cases, employers had discovered that predictable insurance premiums were easier to manage than unpredictable jury verdicts. The uncertainty American businessmen invoked was not a fact about the world. It was a choice not to look, and then something genuinely unexpected happened. American employers started switching sides. Not because they had a moral awakening, because the arithmetic had changed. Juries in the early 1900s had grown far more sympathetic to injured workers. They had read the newspapers, they had seen Monongah and Cherry and Triangle, and they were increasingly willing to find their way around the three doors and hand down large verdicts. Liability insurance premiums climbed, litigation costs climbed, and a company could no longer predict, from one year to the next, what its accidents were going to cost. Business didn't want generosity, business wanted certainty, and a compensation system with fixed schedules and no lawsuits offered exactly that. So by 1911 you had a genuinely strange coalition, labor organizations who wanted injured workers paid, progressive reformers who wanted the carnage documented and stopped, and industrial employers who wanted their liability capped and predictable. That is the coalition that finally moved, but somebody had to prove the case. And the person who did was a 26-year-old woman with a law degree from New York University and a master's in sociology, who arrived in Pittsburgh in 1907 to do a piece of research nobody had attempted. Her name was Crystal Eastman. She was hired onto the Pittsburgh Survey, an ambitious social investigation of an American industrial city, steel country, the heart of it. Eastman's assignment was work accidents, and instead of collecting stories, which is what everyone before her had done, she did something devastatingly simple. She counted. For one full year, from July of 1906 through June of 1907, Crystal Eastman documented every single work-related death in Allegheny County, Pennsylvania, not the famous ones, not the ones that made the papers. All of them. She pulled coroner's records. She tracked down families. She sat in kitchens and asked widows what they had received and from whom and how they were living now. 526 deaths in one county in 1 year. And she published what happened to those families in a book called Work Accidents and the Law in 1910. Two findings changed the argument permanently. The first was economic. Roughly half the families who lost a breadwinner received essentially nothing. The employer's contribution to the household was, in an enormous share of cases, 0 or a sum so small it covered the funeral and nothing else. The second finding was the one that mattered more, and it's the reason her work outlived her. Eastman analyzed cause. And what she demonstrated, case by case across 526 deaths, was that in a very large share of them, nobody had been negligent in any way the law would recognize. No villain, no dereliction, nothing you could point to in a courtroom. Men died because industrial work at industrial scale kills a predictable number of people per year, the way a foundry produces a predictable amount of slag. Understand what that does to the debate. Everyone had been arguing about the three doors, whether the fellow servant rule was too broad, whether contributory negligence was too harsh. Eastman didn't argue that the doors were unfair. She proved they were beside the point. If most industrial deaths involve no legal fault by anyone, then a legal system built entirely on finding fault is not a flawed tool. It is the wrong tool. You cannot fix it by adjusting the doctrines because the question it asks, who is to blame, has no answer in most cases. The only sane question left is, this cost is going to occur. Who should carry it? The worker who is dead or the industry that produced the profit and the corpse together? Eastman took that finding into New York's Wainwright Commission, where she helped draft the 1910 law. That's the law Ives destroyed. She watched her own work struck down. And it didn't matter, because the research survived the ruling. Other states copied it, and they found a way around the constitutional problem that is, frankly, beautiful. Wisconsin, May of 1911. The first comprehensive Workers' Compensation Act in the United States to take effect and survive. 9 more states followed within the same year. The trick was this: to dodge the due process objection, the early laws were made elective. An employer could opt out. Nobody was forced. Perfectly constitutional. But if you opted out, you lost the 3 doors. The state stripped away the fellow servant rule, contributory negligence, an assumption of risk for any employer who refused the system, and turned you loose in front of exactly the sympathetic juries that had been terrifying industry for a decade. It was a trap, built with real elegance to catch the men who had spent 70 years building traps. Employers signed up in droves. And that is the bargain America made in 1911, and it is still the bargain today. Injured workers gave up the right to sue their employer. They gave up the possibility of a large verdict. They gave up damages for pain and suffering entirely. In exchange, they got payment without having to prove fault, and they got it in weeks rather than years. Certainty for both sides, at the cost of justice in the individual case. That's the deal. Every American worker is still living inside it. Adoption moved fast after that. More than 40 states within a decade. But it was not clean, and I'm not going to pretend otherwise. Mississippi was the last state to adopt workers' compensation. That happened in 1948, 37 years after Wisconsin. 37 years in which a worker's rights depended entirely on which state line he happened to be standing inside. Many early state laws excluded agricultural workers and domestic servants, the same carve-out that would appear again in the Fair Labor Standards Act and the Social Security Act, and which, in practice, excluded an enormous share of black workers in the South from the protections everyone else was getting. Small employers were exempted, casual laborers were exempted, and occupational disease was largely left out for decades, because the laws were written around the word accident. And a slow poisoning is not an accident. Silicosis in the foundries, black lung in the coal mines, radium in the watch dial factories, men and women who were being killed by their jobs over 15 years instead of 15 seconds fell straight through the gap, and it took decades of separate bitter fights to close it. And then there was the price list, because a no-fault system needs a schedule. If you're not going to have a jury decide what a loss is worth, the legislature has to decide in advance. So the early compensation statutes contained tables. A thumb was worth a certain number of weeks of partial wages. An index finger, fewer. A hand, more. An eye, more than that. An arm at the shoulder, more still. Death was capped at a fixed multiple of annual earnings, often a few $1,000s. An American body itemized by statute, part by part, in a column of numbers. And I want to be clear about this. That was the reform. That price list was an enormous improvement over what came before, because what came before was Nicholas Farwell being told his hand had already been included in his wages, which is where I want to end, because the arguments haven't actually changed. Every objection raised against workers' compensation in 1911 is still in circulation right now, attached to different subjects. It will bankrupt small business. It removes personal responsibility. Workers knew the risks when they took the job. The market will sort it out. You hear those sentences today about paid sick leave, about heat exposure standards, about who counts as an employee in the gig economy. Those aren't new arguments. They're old arguments with new nouns, and we already ran the experiment. We ran it for 70 years on a continental scale, with the results carefully written down by a woman who went door to door in Pittsburgh and asked 526 families what they'd been given. The answer for about half of them was nothing. It took Monongah. It took Cherry Mine and the men who sealed themselves behind a wall of mud in the dark. It took Triangle. It took a court in New York declaring the whole idea unconstitutional and a state in the Midwest finding a way around it anyway. It took 37 years to reach Mississippi. And it took a 26-year-old who understood that the way to end an argument is not to make a better speech. It's to count the bodies and publish the number. And it started with an engineer outside Newton, Massachusetts in 1837 who did his job perfectly and lost his right hand to another man's mistake, and was told by the highest court in his state that he had already been paid for it. Nobody paid him. He paid for all of us. If this is the kind of history you didn't get in school, subscribe and turn on notifications. There's more coming. Next time, the women who painted watch dials with radium and were told to point the brushes with their lips, and the fight they had to wage while they were already dying. Thanks for watching. I'll see you in the next one.